Hello, this is Steve McNeil.
All right, good morning.
Good morning.
I'm Judge Bashor. I'm covering for today's docket for Judge Evans, who's otherwise scheduled in the middle of a trial. Two issues on for today. One is a change of venue motion and one is a presentation. And I don't know that I had a lot of paperwork that was filed on this one. And a couple of things. There was a number of documents that were filed that looked like they were filed Monday, which wouldn't be timely for today. There's also I don't know, is there an agreed presentation or agreed orders on presentation?
I'm not aware of a presentation issue today, Your Honor. I think we're on for a motion for venue and a motion for a temporary parenting plan and for GAL.
Yes, Your Honor, that sounds correct to me.
All right.
So is Ms. Russell representing Ms. Edmondson, or is she just here because the state has an interest in child support?
I represent the state.
Okay, so if we could, Your Honor, I don't have an objection to addressing the state's order and getting that done today if we can. I mean, I thought the judge was pretty clear. He made a ruling on what the calculation should be, and he indicated that the effective date would be August 1st.
The order was entered at our last hearing.
So if that's been done, I don't think the state has any further interest in this case. I could be wrong, Ms. Russell, but do you?
That depends on what happens going forward. If there's a change in parenting plan, then there could be support implicated. I don't have a particular interest in the motions as they are presented, but if there happens to be a change in the parenting situation, then I would have an interest.
Okay, thank you. So, Your Honor, if the court feels it needs, there is quite a bit of material that's before the court, and I don't know if you want to, there's also some counter motions been filed by Ms. Edmondson. I don't know if those were perfected or if they're properly before the court either. I'm prepared to argue venue today if the court has, if you feel you've had enough time to review those documents. Otherwise, I don't have an objection to setting this over for a very brief continuance to, get better prepared on this.
Well, the issue that I saw was there was on Monday, it looks like on the 22nd, there was 48 pages of text messages and then a couple of healthcare records filed. And then there was a stack of material that came back on bench copies that I didn't see everything in the court file. So I don't know if those were filed or served but the Monday wouldn't be timely for today's hearing in any event.
Yeah, and I think, Judge, just not to cut you off, and I apologize, but I think those were filed in response to Ms. Edmondson then adding a motion for other matters for today. And I was...
Apologies, I thought you finished that thought.
Okay, Ms. Russell, I'm sorry. Go ahead then. I
thought that you had finished that. I was just going to note that the state was not served any of those items on Monday.
Okay, again, child support's over, so I'm not sure what. Little confused.
The state is a party with an appearance and needs to be served.
I'm looking at it looks like, just a second here. There was a motion filed for a notice of so there was a docket notice filed on July 10th for today, apparently for a motion for temporary orders and guardian ad litem. So that's not timely for today. It's 21 days notice for contested hearings. So I guess I'm just not sure what's on today. That's what I was trying to figure out when I was going through the docket for this. And I thought this was on for presentation based on the docket notice, but apparently not. So if it's on for temporary orders, it would need to go over anyway because we haven't had sufficient time to do that. Our local rule 88 requires 21 days court days notice for contested hearings.
So when could we get a full hearing on all the issues then, Judge? Because it just seems like, in the sake of judicial economy, it'd be nice to just get everything heard all in one motion. And I don't know if we can do it on a motion calendar, or if we need to get a special set.
No, we can do it on a motion calendar. It's not a problem. It's just that, I mean, the only thing that's actually on today that I can see would be the motion to change the venue. And I don't know if there was some documents that were filed on Monday, if those have anything to do with that motion, those wouldn't, I haven't looked at those. So, I mean, probably the simplest would be to set this out so it's timely for the temporary orders, the JL motion and the change of venue and hear that all at once.
All right, what's a good date then, Your Honor?
Well, if we probably looking at about the 7th. Because the motion for temporary was filed on the 10th, so we could probably do that next week, would be just timely for that motion.
I'd just like to get everything done at one.
That's fine. Is everybody available the 31st or the 7th? Do you have a preference?
The 7th is okay for me, Your Honor.
Okay.
Yeah, I've got a Department of Licensing hearing at 10. But I could just tell them, it'll have to be trailing.
Well, we could probably get this right at 9. I can have the clerk enter a note on the docket so Judge Evans could address it first.
That'd be fine then, Your Honor. The 7th would work for me then. That would be fine.
And Ms. Russell, does that work for the state?
The state's here for all of them, Your Honor.
Okay, so the 7th of August, and that'll be for all currently pending motions.
All motions. Do we need to do an order then, Your Honor, or will it just be a document?
We'll set that from this docket, so that'll take care of that. So no additional documents need to be filed. Okay, and I would urge the parties to take a look on our website for local rule 88 that governs the timing on all these motions. So for future motions. Okay.
Thank you, Your Honor.
All right.
Yes, Your Honor. Thank you for your time today.
Good morning.
You're welcome. Item is here as well.
So this is one that I tried to determine why this was on today. I didn't see a motion for today. So maybe
Your Honor, I can clarify if the court is ready.
Sure.
We have been trying to establish reunification counseling between the child Parker and his father, Stevie Utter. This has been going on for many months, close to a year. At the last hearing, Parker was balking at the reunification counseling, didn't want to do it. And I was not ready to give up on the matter, and neither was Judge Evans. And so we scheduled a hearing today to review how the reunification counseling has gone. I contacted both Kirby and Stevie yesterday. Both have indicated that there have been no further sessions since the last hearing. And Parker is still objecting to doing the reunification counseling. So at this point, I'm willing to drop that.
okay. Where does that put us on this case? As there were several, again, I don't have again a motion filed. I'm not sure exactly. Looking back in October, looks like there was a bench order signed by Commissioner Kirby. So maybe you can bring me up to speed on what Judge Evans has been doing on this case. I didn't see, again, there's no motion filed for today, so I'm not really prepared to address an issue unless there's something that is before the court. That's what I was trying to understand.
Your Honor, I don't know if anybody has been in contact with the reunification counselor herself. Last time I talked to her, she'd only talked to the Keith one time. And that was prior to our last court hearing. So I don't know if there's been any current communication with her.
I have not contacted her directly, Your Honor. I did speak with both of the parties yesterday, and there's been no sessions scheduled, or maybe they've been scheduled, but there's been no sessions that have occurred since our last hearing.
There have been several scheduled. She was available every Tuesday since our last hearing, but they've been canceled for various reasons on all parties' parts. I don't think we should give up, nor does the counselor. But that's my part.
Okay. The last note indicated that, I'm just, again, I guess I was trying to determine what this was on for today. It looks like there were some cancellations by the provider previously, and there was a waiting for the provider to reach out. So I don't, has that been done? Has the provider scheduled some things? Is that what I'm hearing?
Yes, she has.
Okay.
This has been, I think the counseling itself has been almost going on for a year. And I would say there's been maybe 5 visits, maybe. And it's just, the whole thing's been going on for probably close to a year and a half now.
Mhm.
There's just been no moving forward. Parker's expressed to the counselor and to Stevie that he does not want to do this. I don't know what more as his mom that I can do. I feel that this has ran its course and he doesn't want to do it. He's 12 years old and Stevie has been absent for 10 years of his life. I don't know what more as his mom I can do.
Well, that's why we're here, Your Honor, so that we can have help from the courts, hopefully, and accountability when cancellations happen. I realize there's emergency situations, but they've been over beyond. The reunification counselor has suggested personal counseling for Parker that the courts had, I believe, agreed with. I don't know where we are with that. Parker has gotten any individual counseling or not on the situation. Today, as every day, just need some help from the courts here because we're stagnant. We're not going anywhere. Yes, it's been a year. Everything was good before we came to the courts until it wasn't. And that's why we came to the courts for this help. And again, we're nowhere.
Well, Mr. Lawrence, I'm looking back through the file here. I mean, I see there's a parenting was entered at August 23rd of last year, which looks to be fairly standard.
We did that ourselves
Together, yes, correct.
and that did not work out at all. And
They
so
never got the chance, Your Honor.
came back to court to do the reunification counseling. There was no prior relationship with Stephen and Parker. So
Okay, well, Mr. Lawrence, I guess what I've got right now is I've got a parenting plan filed August 23rd. That's the only order that I see. Well, I guess there is another order, and I don't know how that other order got put into place because there's no motion modifying the parenting plan. So we've got a bench order filed October 4th. That
It's not put in place.
know that they paused the parenting plan or whatever till further notice.
Well, if nothing else, is it time to enforce that so we can actually move forward?
You can't enforce a parenting plan when Parker doesn't know you. That's just cruel.
If I can have it, I did need to be stopped for a minute. I mean, you've got a current order, you've got a second order, which was filed in October. I don't know how the October order was entered because there was no motion modifying the parenting plan. And I don't know, Mr. Lawrence, I saw you had a report that you filed sometime ago.
I did, Your Honor. Yes.
So I maybe at this point, if we could get an updated recommendation from the guardian, but at this point, I mean, there's a parenting plan that's in the file. There is an order placing that on hold. So that's where we're at, as far as I can tell. I don't know the basis of that order because I don't have anything in the file that tells me why we're here today.
I think we were just here for a review of how the reunification counseling was going. And obviously it has done nothing since the last hearing.
There's no accountability. It will continue to be canceled if we continue to do this unless there's accountability from the courts.
Well, do we have any kind of report from the reunification counselor? Because I have the order on October 4th says future visits will be guided by input from reunification counseling after review. You know, I don't have anything in the court file after that.
He's not provided anything, Your Honor.
She hasn't been contacted but one time. She's been waiting to get contacted. I've communicated with her on this.
Okay, so I'm a bit of a loss here. I mean, you have an order that says there's going to be some reunification counseling entered in October, but it doesn't have any specifics on it. So, Mr. Lawrence, I think what I'm going to ask you, if you could do this, if you could reach out to the reunification counselor, get some guidance as to what they think is appropriate. And then we can set this out a couple of weeks and we can get a recommendation from the guardian ad litem as to how to proceed on getting that to move forward, then we can address it.
Okay.
I apologize, I'm just at a loss. I haven't been following this case and I don't have any guidance as to even why this is, why we're having issues, so. So how much time would you need for that, Mr. Lawrence?
Probably 2 weeks, Your Honor.
Okay, let's put it back on for the 7th, and with the guidance that Mr. Lawrence will reach out to the reunification counselor, see if we can get a recommendation for a specific plan that we can put into an order and then have the parties follow that. Because what appears to me is there's really no court guidance as to what they're supposed to be doing, which is why nothing's happening.
Correct.
Okay,
Okay, thank you.
Thank
All
you,
right.
Your Honor.
you're welcome. But
I'm
here,
here.
okay, this is another case where it is unclear why this is before the court today. The last notes I have indicate there was some sort of appeal going on with the state of Oregon. And there was a request to set it over to today, which was done.
We're still currently waiting on Oregon to respond to the appeal. We filed a central review for 7/18.
Okay, so at this juncture, you just need some additional time?
Correct.
Okay,
And Mr. Lyon and I are both in agreement with another continuance.
all right, is that accurate, sir?
Yes, it is.
How much time do you think you'll need to get that feedback from them?
For the central review, I was told it would be another 30 days for that to come back. So I'm thinking like mid-August probably, and just continue with our regular schedule for now.
You want to try for the 28th of August? That's about a month out.
That works for me.
Yeah, that works for me too.
All right, so 28th August at 9 a.m. for further review.
Perfect. Thank you.
You're welcome.
For Mr. Stefan.
Good morning. Again, I apologize. This was I was unable to determine why this was on today.
It's on for entry of orders. There was a order on the contempt hearing order, and then there was a temporary parenting plan that was supposed to be entered today. And so I think that we've submitted the signed contempt order, the signed by myself and the petitioner, Ms. Carroll, and we're here for entry of the temporary parenting plan. Do you have copies of the order, Sharon?
Just looking here,
You don't even know why it's happening.
I have orders, but they're signed off by you. I don't have a signature from the other party.
Oh, we did submit that after we submitted the bench copies of the order. So
Let's see if I've got something a little farther down in my file here. Just a moment. I am not seeing. Yeah, I do not seem to have an updated version of that order, counsel.
okay. Well, I think the hearing, what are called, the contempt hearing order is agreed to. And so you should have a copy of that. It's just signed by me, but you also have a copy of the temporary parenting plan order.
I have copies of that. Well, they're originals, but they're only signed off by yourself.
Right. Okay. So I think the contempt order is agreed.
And Kimberly, are you with us today?
I am, Your Honor. I'm here.
All right. And did you have a chance to look at those proposed orders?
I did. I didn't have very much time to seek legal advice on them, and I was waiting to hear back if Eddie was in agreements for the anger management and parenting courses that I wanted to add to the parenting order. And then I also spoke to Sam, the DV evaluator, this morning, who said his report wasn't finalized for collateral input, and it probably won't be until the end of the week. So I was hoping we can get a continuance.
Let me ask you a question. Did you see the contempt hearing order essentially just denied the contempt hearing? Is that?
Yeah. And I was in agreement with that. I knew that he wasn't making the steps or the moves to do anything that the court had ordered. And so I was advised to do the contempt order. And now in good faith, he is doing what he needs to do. So I signed off on that in agreements that he's no longer in contempt, and I agree.
Okay, I will go ahead and enter the contempt order based on that representation today. So that one I've signed. The other one, since I didn't do that hearing, I thought I set that over a week or so for Judge Evans to be here, and he can make a decision about whether the language is what he'd ordered.
Okay, when would that be, Your Honor?
Well, what's your schedule? You need to do it next week or the week after. He's normally here every Wednesday, but we had to do a calendar switch to do a trial today. So
I can do it on the 30th.
It'd be the 31st or the 7th.
I prefer the 31st.
Does that work for you, ma'am? Be next Wednesday.
Yes, Your Honor, that's fine.
Okay, so put it over to the 31st. And that'd be at 9 o'clock, a Zoom hearing just like this. And I will have my clerk carry these orders forward, and we'll see where we're at.
Okay, thank you. Have a nice day.
All right, you're welcome. You too.
Hello.
Good morning. This one again looked like it was short service for today. I think I saw, let me just double check something here. This was served on July 9th, it looks like. So we're about a week early to address this one. Based on the court rules. And I don't.
Does it show? Sorry, excuse me.
And I do have a return of service. It shows service on the 9th.
What was our first date was 2 weeks ago, and she had the other party, she was there and had to actually pick it up from the sheriff's office because they hadn't served her. And so the last time the judge had put it out 2 weeks, saying that would give enough time. So I'm not sure if you see conflict on your end for that, but I'm not sure how much time needs to go by anyway. So,
well, the court put it on for today.
And I'm the attorney for Miss Plumunden. It's an attorney matter.
Okay. Well, it's on this docket till we get this particular bit resolved, I believe, but it looks to me like this would be on for next week before we have sufficient time under Rule 88.
Okay.
So, I mean, I could set it out one more week to the 31st, and then I don't know that I've seen any responsive documents
No, she doesn't wish to respond. And in fact, she couldn't make it today. And
All right, Ms.
since
Townsend,
we were in agreement, she said, well, I know and we know what's going on. So, anyways.
all right, Ms. Townsend, you're representing who on this case?
I represent Mrs. Plumunden, if this is the Plumunden matter.
No.
This is the
Sorry.
Wakefield matter?
Sorry, I didn't hear that, Your Honor. I apologize.
Okay. So let me set this out one more week, and then if we don't have any responses, it should be able to move forward based on the service date of the 9th.
Okay.
Okay, so put it up to the 31st at 9 o'clock. And I don't know, did you provide some orders? I think I saw some. This one, I do. So I will make sure those are carried forward to next week.
Okay.
Okay.
Thank you.
You're welcome. At number, I don't know which number this is, but it's the Anthony Cox and Destiny Peters Ritzenthaler. Anybody here on that matter?
Yes.
All right. I looked through this file and I don't see any motion or anything why this would be on today.
It's because she was given 30 days to respond back to what I served her because she had no paperwork done. So 30 days, and so he pushed it to today's date.
Well, it was sent over to July 10th.
That was a mistake.
It was clerical error. The clerk's notes did not reflect the proper date.
Okay.
So it really was supposed to be set over to today, not then.
Okay, well, there was also, it looks like there were a number of documents that were filed.
Yes, I got those on Monday from her.
Okay, so it appeared to me this was on an error, and I talked with the clerk's office yesterday, and they indicated it was on an error. We were simply going to strike it today, so I haven't reviewed any of these documents, so I don't have any idea why this is on for today.
Well, that's okay because I'm still wanting the temporary order to be in effect because I don't. So basically, what happened is Terry is her significant other that she is living with my son is a very abusive person, and I have
Well, hold on just a second. Is there an order in place currently?
Yeah,
There is no order in place at the moment other than a protection order.
Yeah, I don't see any order in this case.
There should be a temporary order for me to be getting him.
I don't think Judge Evans accepted it at our last hearing.
But he also didn't deny it, so I assume.
Oh, he would have to specifically sign. There's no orders entered after May 22nd.
So would I have to refile temporary orders?
Well, if this was put on, if it was supposed to have been on today, that's again my error. I was reading through the notes. She's filed something in response. So at this point, we probably just need to set it out to give you an opportunity to respond to that if you choose to. And then we can have Judge Evans address that. I can either do that next week or the week after.
I would like it next week.
Okay. So put that over the 31st at 9 o'clock. And again, there are some responsive documents filed, and we'll assume that's on for the motion for temporary orders.
Okay, so next week.
Next week would be the 31st, okay. 9 o'clock, and that's either Zoom or in person.
Thank you so much.
All right. You're welcome.
Thank
you. Okay. Anybody here on that matter?
Yes, sir. Brian Phelps.
All right. Good morning.
Morning.
Is Emily Dietrich present? I'm seeing her. Let me just 1 second here. I don't know that I had an order from you, sir. This looks like this was on just simply for summary judgment.
Yeah, it's the acknowledgement of parentage.
Okay, so it looks like she was served this on
4/27.
Yeah, I don't have a response, so I don't have an order from you to enter to grant the order. I can make a note in the file that she's not responded and it appears to be in order to do that. So I don't know if you prepared an order, but you'll need to prepare an order granting the summary judgment.
Yeah, it should be. Is it not on the the paperwork that I served her on the proof of service? It should say on there that's what I served her, because I seen the the other judge, I can't remember his name. The first time I did it, when I gave the proof of service, I just put the FL numbers on the proof of service, and he wanted the names of each document that she got served.
Mm-hmm.
And so I did that, and we messed up, and it was 7/2/24 that it got amended, and we put 4/2, so I had to redo it. So it was amended again just for the date. But I wrote down everything that I served her on the.
Right. I see that you've done everything correct at this point, but I need a paper order to enter in the court file.
Okay.
So you'll need to prepare the order granting your motion and provide that to the clerk so we can get that entered.
Okay. Well, what exactly is that document?
So if I can't give you legal advice, I don't have the document in front of me. It'd be the order granting the summary judgment. What I would suggest, sir, if you probably want to get some legal guidance on this. If you stop by the courthouse, I believe every Monday from 12 to 2, I think we have some volunteer lawyers that are available on the second floor.
Right. I went through Wakai Cowlitz legal aid. They sent me to Erin Winkles, and she's the one that gave me all the documents that I needed to do this.
Okay. You've got all the right paperwork filed. Okay, that's correct. But you need the order, which you may have served that on her, but I don't have a copy of it, so I can't sign anything today.
Goodness. Okay. Let me look through, because I got copies of everything I served her.
Mm-hmm.
Motion for summary judgment, parentage, right here. That's what you're talking about?
No, what I'm talking about is the order granting that motion.
Okay.
And so, again, you probably want to either talk with Ms. Winkles or legal aid, and they can give you what documents need to be signed based on your requests.
Okay.
Once you get those, I mean, she's not responded, so I'm going to grant your request, but I don't have any paper orders to sign that I can find here anywhere.
Okay, so I just need to get that order granting summary judgment and file it with the clerk?
Right, and bring that in, and then they'll get that either in front of myself or another judge for signature. You wouldn't need to schedule another hearing at this point.
Okay.
Because you've done that, you've given her notice, she hasn't responded, so we'll grant the orders, but I need the orders to sign.
Okay, all right, I got you. Okay, thank you.
Right, and Ms. Winkles could probably give you some guidance on that if she helped you previously as to what orders need to be actually filed or signed by the court.
Okay.
Okay.
Do I have a deadline to get that done? I mean, I'm trying to do this as soon as possible, but I don't, I mean, is
there's not a deadline. I would suggest you do it sooner than later, though.
Oh, yeah, absolutely.
Okay.
All right, thank you, sir.
All right, you're welcome. 08. Okay.
Is that all?
That's all right, sir. Yes. Morning.
Good morning, Your Honor.
It looks like, sir, you filed a declaration today.
That is in response to her response that I was emailed to at 6 o'clock last night after court closed.
Okay. So I assume you have not seen this yet, ma'am? You're muted. So 2 things, neither of those responses would be timely for today.
We were set over to today from the 10th because I filed the paperwork and had her served on the 27th of July or of June. Because she hadn't done a response until last night.
I don't see, none of those were filed with the court. But I did see a bench copy that came in yesterday. I believe it when I saw it. Where did that go? Where did that go? I know I saw it. You're missing something. I saw it because I read it last night. So at this juncture, I mean, I guess there's two things. I know she filed something which came in, I assume it was yesterday, or that's when I looked at it last night, before today's hearing, and my notes indicated that you said she did it. She said she didn't, so I was going to deny it. You've now filed some additional, which it does sounds like she's not seen. So I mean, I can set it over and have her look at that, and then we can have another hearing. But I mean, I don't have a basis to do anything today.
I understand that this is the third time that I've taken her to contempt, and I'm jeopardizing my job right now by missing days of work.
I understand that. I just, I set this out a week or two. You can appear via Zoom if you'd like, and that's perfectly okay.
Either or is fine. The 31st would work because we also have to work that day also.
Okay, well, let's put it on for the 31st. That your documents are here, that you filed these with the clerk?
Yes, I filed them this morning.
Okay, and you sent a copy to her?
Not yet, no.
Okay, so she needs a copy of this as well, and you can do that. You were served via email, you said?
I was served via email that were photos of her response from Ashley.
Okay, so ma'am, I'm going to have him email you what he just brought in today. I'm going to put this over 1 week to next Wednesday, the 31st at 9 o'clock, and then we'll address the issue of contempt. Okay?
Okay, thank you, Your Honor.
Okay. And we'll go ahead and hang on to these so these could get to Judge Evans, and he'll be here next Wednesday at 9.
That's fine.
Okay, and again, if you want to appear via Zoom, you're welcome to, if that's helpful. Okay.
I'm here, Your Honor.
Good morning. Is Devin Keith present? So let me see here. This looks like, it looked to me like this is just entering the restraining order that was already granted in the decree of dissolution. So I will enter that order today.
Okay.
All right, so I've signed that order, ma'am.
Okay, thank you.
You are welcome. I should take care of that case for you.
Thank you so much, Your Honor.
Welcome. I don't believe that is a case I have on today. What was that? Do you have a case number?
Yes, I can give you that. Just 1 second.
You may have it under another name, so I
don't think so, but it's coming up in a second. I'm just waiting on the computer as usual.
I'm going to call one other while we're waiting.
Yes, absolutely.
Janice,
I can put it in chat as well.
All right, Janice Cuevas and Humberto. I assume you are Janice?
I am.
Okay, so give me just 1 second here. This was, do you have an affidavit of service as to when this was?
Yes, it was served on the 14th.
Okay.
And it was filed yesterday, or no, it was filed on Monday. But there was a problem and then called me back yesterday to come and fix it yesterday morning.
Okay, so it was served on the 14th.
But the problem that I realize is that he hasn't been given adequate time.
Right. So I just need to set this out a couple of weeks and that'll, okay. So sir, it's our rule requires 21 days notice for you to respond. So you got served on last Sunday. Does that sound right? Okay. So if I put this on for, let's see. If I put this on for the 7th, which is 2 weeks from today, 9 o'clock, that'll be within the court rule, and then we can proceed.
7th of August?
I'm sorry?
The 7th of August?
7th of August at 9 o'clock. And you should, if you get some legal advice, you need to do that quickly. There are some timelines for filing your responses. So you need to do that pretty quickly. If you agree with everything, that's fine. If you don't, you need to get some paperwork filed. Okay. All right. So I'll set this out to the 7th at 9 a.m. And based on your confirming service on the 14th, that'll be a good date for the hearing. Okay. If you go to our website, there's a local rule 88, which talks about the timelines. And if either of you have a question, if you can show up on a Monday from 12 to 2, there are some volunteer lawyers that can give you some guidance.
There was some problems because the sheriff's department, it was filed on during the holiday. They weren't able to serve it.
That's not unusual.
Were gone for the weekend, and then I think he was gone.
Okay.
I think he was away, so there was a problem with service.
Yeah, it would have been a challenge no matter what, because even if you would have served it the day after you filed, that would have just been sufficient.
I realize that.
So we'll set it out 2 weeks to the 7th, 9 a.m. and we'll come back and we'll hear your case.
Thank you so much.
You're very welcome. So this was set out to today also for as time limit issues. Did you receive the response, ma'am?
I did, yes.
Okay. So, Ms. Russell, is the state involved in this particular motion?
I don't expect to be, Your Honor. There were some support issues raised verbally, but I don't believe they're in the written motion. So I just asked to be heard if support issues end up at issue.
It looked to me when I reviewed the motion, this is the one filed June 26th. This is, it's an issue of child care payments, and I think that's everything that's on the motion.
Yes.
So, all right. So, sir, did I did see your response. You filed that on the 17th, and it basically you're not agreeing with the amounts or something. Is that right?
Then I'm not agreeing with all of it because I didn't agree with the babysitter or what we have. It's supposed to be licensed and 50-50 that we chose together, and none of that's ever happened. And I get no invoices from the babysitter what she's supposed to give me. So I don't know if the kids are there or what's going on. So
let me check something here. This is on a temporary. I think I looked back at that, and just a minute here. I'm not seeing the support order. There it is. Okay, so this is the order that was entered. Looks like it was in September of 2019 was the order that we're working under. And when I go down through that, it's proportional share of daycare, work-related, employment-related, and it's the same proportions that you're currently under your worksheets, which is not in front of me here. Looks like that would be, so it looks like you're responsible for 51%, 52% of whatever those are. I don't see anything on that. Let me see if there's something in the other order here, because I didn't see anything that required choice. Do you have any response to that, ma'am? I'm just trying to.
Yeah. So Megan Rasmussen started watching Easton and Ava back in April of 2021. So they were very well established with her. Shane has mentioned a few times that he wanted a new childcare provider after some issues came about. I've tried. The kids have been on a wait list at the daycare in Castle Rock. I just couldn't find other childcare. The kids did not want another childcare provider. And with what he is requesting from Megan, she's not a daycare facility. She's not licensed. She's a babysitter. And the kids, she's no longer watching them anymore due to not being paid. She had to get another job. So I would send him invoices myself. He didn't want any contact with Megan. He didn't have Megan's phone number saved in his phone. I would send him invoices every other Friday, letting him know the total amount, his part and my part. And I sent in screenshots to the court of me sending those invoices to him. So
Okay. So you got some kind of billings and you sent those to him?
Correct.
Okay. And did you receive those, sir?
I did, but I've asked from the babysitter to send them to me to use for my tax credit because I pay a lot of money and I get nothing to show for it, no receipts or nothing. So, and she has like 6 kids in there she's watching. So to me, that would be a licensed daycare, I would think. So making that much money tax free.
Okay. Well, so here's the problem. That's really kind of a separate issue from whether or not you're required to make the payment. If you disagree with the daycare provider, that you probably need to come into court and request us to order some different order, because your order doesn't require specific agreement on that. That's not unusual to require that, but it's not in the order that I see. So the problem is she's got bills that are getting paid, the kids are getting watched. If you disagree with who's doing it, that's an issue over here, but the payment still needs to take place until that's resolved. So
more time to get that order into,
can you do what?
get a little bit more time,
Or
to get, just, I don't know, I gotta see what I gotta do for that other order about the licensed daycare and all that stuff.
that's a separate thing altogether. What we have right now is we've got some bills that haven't been paid that you were supposed to pay under the current order. And what I'm seeing here is you haven't paid those. You haven't paid those, not because you didn't get some kind of billing or that they're not owed, but you don't agree with the provider.
I don't agree with the provider, yes.
Okay. So until there's a change in the provider or you get an order that requires a different provider, you still need to pay the bill under the existing court order. So do you have, it looks like there's, I mean, you certainly could file a motion and ask for some different results as far as how that process takes place, but that's a separate process from what our existing order is. I mean, it's reasonable to get a copy of whatever she's providing to you. So I don't know what she's provided to you. Have you sent that to him, or are you just sending?
Excuse me.
Have you sent him what she sent you as far as what you're owed?
So I keep track of the days that the kids are there,
Mhm.
and then every other Friday, I pay again my share, my portion, and send a text message to Shane. And they've been different depending if I had to take that day off,
Okay.
or if the kids are on spring break, or
So she's not giving you anything.
no, I'm keeping track of it.
Okay. So she still needs to give you some kind of a document, like a bill of something as to what's owed, or at least some kind of signature verification that I did this and you owe me this money, because I mean, first off, she needs to be filing her taxes and all that kind of stuff on
Right.
the money. You also potentially, if you paid more than, I think it's $600 to her, you're required to file some documents with the IRS, or you are required.
Okay.
So there's some requirements that you need to do if you're doing that. At least that's what it used to be. So what we've got here, obviously, nobody's disputing the child's at daycare or being watched. No one's disputing that there's a charge for that. So let me ask you, sir, currently, at least at the time this was filed, she is saying that you owe her a little over about $2,400. That's quite a bit of time. So that's 2 months. That's through June. Did you pay any money during April, May, or June?
I believe so. I would have to look at my my stubs that I went and got cashier checks. I'm not sure where I got there.
Okay. So how soon can you pay that?
I can get off pretty soon.
What's pretty soon?
Like a couple months, and then I'll pay it off.
How much can you pay, say, like in a week or so?
Couple hundred, few hundred.
Okay. So how much can you pay, say, like every 2 weeks? You pay every 2 weeks?
Yes.
Okay. So here's what the problem is. You've got a bill that's kind of built up
Mhm.
that we need to get taken care of. Plus, I assume there's ongoing daycare costs. I don't know. I assume your children are someplace.
My best friend is watching them right now.
Okay. Is that costing you anything?
I paid her $200 this last Friday.
Okay. So a couple of things here. What you need, however you're doing that, you need to get something from whoever's doing the babysitting that documents, I've watched them these many hours at this rate.
Okay.
Doesn't have to be real formal. Both you and they probably need to talk to somebody about the whole tax implication, because you can get into some other issues.
They're looking into that. I
Okay.
didn't know that I had to file. I thought it was optional to file your childcare costs
No, there's a requirement if you're paying somebody to do services
To do survey, okay,
Like if you hire somebody to remodel your bathroom or something,
Right.
I mean, if you pay over a certain amount of money, and I think it was $600, I believe, you're supposed to file a document, so you may want to check on that.
Okay.
I mean, my goal is trying to keep you all out of trouble.
no, that's good to
And
know.
don't take that as legal advice. That's just my understanding is there's some tax rules you all need to follow. So here's what I'm going to do, sir. I am going to make a contempt finding because you essentially just haven't made the payment. And it's not because the money's not owed, it's because you don't like the provider. Okay, so that's a separate issue, and you certainly can file a motion to this court asking for some modification in those orders, and we'll be happy to look at them, and I'll hear what she has to say, and we'll make some decisions. In the meantime, you still got to pay the daycare. Okay, so I'm going to make that finding. I'm going to give you an opportunity to purge that, meaning you kind of get yourself out of trouble by paying whatever the current bill is on a monthly basis, and then $200 a month towards this.
Okay. Can I get a statement for the past 3 or 4 years of what we paid from her?
You can ask for that. I'm working off what's here.
Okay.
And, but going forward, you need to have some kind of documentation as to what it's costing you so that he can see that. And either he needs to reimburse them directly or pay you so you can reimburse them.
Either way.
Yeah, however is fine, but that's how, so that's what we'll do on this one. Let me see here just a second here.
Your Honor, if I may ask a
Yes, ma'am.
question.
Sure.
Is there going to be a guideline of how long he's gonna have to pay her? Because the last contempt hearing that we did last year, it seemed like it was over the same issue of no payment.
Well, he's got to pay $200 a month towards this arrearage plus whatever your current is.
Okay, and if he misses payments or doesn't.
You can bring it back in.
Okay.
Yeah. Okay. So, and I don't know that I have an order on that one. Okay, so I need to have you do up a contempt order, the actual document I signed that grants your, did you get one of those possibly? It should say order on contempt.
Order for the court.
Yeah, this would be a blank order that probably hasn't.
I do.
You don't. So I need that order, and I can set this over a week or two for you to put that together.
So
And then
that's the paperwork for you to sign.
correct. It's the actual order on contempt. That's the title of the paper, or order on contempt hearing. I think that's what it's called. Yeah, it should be form number 167. If you go to the family law forms. In the clerk's office, I don't know, do you guys have those out there? Okay, so they probably can get you one out in the front office out there. And you just need to fill that in. I'm granting your motion for the money that's owed. And he's in contempt, but he needs to pay it at $100 or $200 a month plus current billings. Okay.
And I will, yes, get that invoice to him.
Okay, and if you both sign off on that order that this is what I said, then you can just submit that to the clerk. Otherwise, I can set it over. Probably should go on my docket. I normally do presentations on Fridays at 8:45. That's a Zoom hearing, so you would just send your document in to the clerk if you don't agree on the paperwork. So you're going to prepare an order that says what I said.
Right.
Send a copy to him. If he agrees that that's what I said, then he can sign that, and then you just bring that in. If you don't agree with what the paperwork says, then I can set a time for you to come back and I'll take a look at it and fill that out. So.
Just set it over. We can do that.
Okay, well, let me give you a date. And if you guys agree on an order, then you can just let the clerk's office know and they could strike the hearing. Okay. So I can either put it on next Friday, the 2nd, or 2 Fridays out on the 9th.
We can do the 9th.
The 9th? Okay, so 9th at 8:45. And those are Zoom hearings. So there's not an in-person availability. So you just log in, send the clerk's office your proposed order. So I've got that. And make sure that's at least a few days ahead of time, and then we'll get you an order entered. And in the meantime, you got to start making your payments and get that taken care of. And if you want to have us take a look at how that whole process works, be happy to take a look at it.
Yeah.
Okay.
Thanks.
All right. You're welcome. I think we lost our other attorney.
She was on the wrong Zoom link.
I assumed that was the case
Yeah, she
because,
sent the case number and she was supposed to be on Universal Post.
oh,
I think that's it, right?
that would have been a different docket. At a different time. It always strikes me as interesting when you ask an attorney the case number of a case that they're appearing on and they can't find it.
She didn't know.
It's like, how in the world do you?
Well, and then the case number she sent me had an 06 on it instead of an 08. And
We were supposed to be in Vancouver, isn't it? Vancouver.